How can I do a letter right now? Be down in a minute. Okay. Oh, okay. I'll go do that. Bye. Is that slideshow, right? Or right here? This little one right here. Click right there. Yeah. Okay, perfect. You're on. Thank you, Violetta. Welcome to SAC. Appreciate you being here. You got your clicker there. Awesome. Okay.
Yeah, got it so much. Thank you so much, Kim. Okay, I'm going to get my
morning today. We have the two classes, one business and open there.
You know what? I am going to try to talk about both. My specialty is estate planning, but I'm also a business law attorney, so I know a little bit of both. So today, ask me anything, and we can stay late if you have additional questions. Let's see. Here we go. So I'm Violetta Schultz. Remember the name, I'm the only Violetta Schultz in the entire United States. So if you don't need me now, but if you need me later in the future, reach out. You are going to find me in LinkedIn or you're going to find me somewhere. I'm always online. I am licensed to practice law here in the state of California and Mexico. Okay. So I have that additional ability to help people that has ties with Mexico, Spanish-speaking families or people that has buying property or has property there. So it's
So if someone is buying property in Mexico,
yes, because I'm familiar with both jurisdictions. So more than simply speaking the language is I understand the law, I understand the culture, so that makes my niche easier. Yes, that's my contact information. But again, most of the people I'm helping today, they met me months ago or years ago, and they are able to find me because I'm very present online. Okay.
Bye.
Yeah,
I want to get the email address.
or you can take a picture. That might be easier. Yeah.
We have a copy seat and a name card.
Yes, I'll give you a physical card too, but that's another thing. A lot of my clients, they come from a picture that someone sent them on my card.
Yes, right.
Oh, I know. So the learning goals for today is, let's see if I can move. Perfect. What is estate planning? What documents are needed? Why avoiding probate is a smart thing to do? How to prepare for loss of capacity and general things about your business. That's what we're learning today. Feel free to stop me, ask any questions. What I want to do today is to truly make sure that you know exactly what estate planning is, what is a will, what is a living trust, the differences, what to do, because you can educate other people.
Can you take it?
Sure thing.
Sorry.
Thank you. Sure thing. So, as easy as it is, what is estate planning? Estate planning is the process of preserving, accumulating. Of course, everybody that works right now, we're accumulating something, right? We're creating and figuring out what we're going to leave to the next generation. We preserve one's property to transfer during person's lifetime and after death. So estate planning is not only something you do for when you are gone, it's someone you start planning now. We know a lot of people that is gifting. I'm going to give half of my house to my granddaughter because I know that's what I want to do. I don't need the house. But estate planning allows you to think about, okay, is there going to be a tax issue there? Is there going to be issues because she's a minor? Is there going to be a reassessment in your lifetime because you're giving a gift to someone? So estate planning is still when you're doing your lifetime, but also when you pass. And it helps you minimize taxes, state recovery, like medical, Medicare, things like that, probate cost, while following your wishes. Estate planning involves, these are the main documents that you're going to learn about today, but then you should also have and understand. Not everyone needs everything, but let's understand them. So wills, trusts, power of attorneys, and advanced healthcare directives. Many times I work with legal experts in different fields, tax experts, and financial professionals, because everything we have has to do with that too. Documents that you need today, now, simply because you're like a power of attorney. There are different types of power of attorneys. This allows you to make a decisions now that who's going to take over your shoes if you are incapacitated. During COVID, when there was a lot of people that was unconscious or with tubes that weren't able to make decisions, power of attorneys are those things that allow someone, a child, a brother, a wife, a friend, someone to be able to manage your personal finances, your personal assets. Things such as taking money from your bank account to be able to pay your mortgage, little things like that. So everyone should have that. And an advanced healthcare directive, that's key. That's super, super important. And 90% of the people don't have them. And an advanced healthcare directive is just specific terms for health. If you're unable to make decisions, who's going to make them for you?
So the power of attorney it's for more than just a health thing, but advanced health, it's just for.
See it as different items. A power of attorney is for finances
Okay.
and personal belongings. Advanced healthcare directive is your communication with the medical providers. Mhm.
Thank you.
The psychiatric advanced directive, that's something that I rarely see and rarely do, but that's another directive that has to do with psych.
Okay.
Now, a lot of my clients, the majority of my clients they come in different age groups. They're either in their 30s, 35, the majority, or 70 and over. And the reason that happens is when they're 35, and with the current information that is available out there, as soon as someone purchases a house or has children, they want to talk to an attorney to make sure they're doing things right or they're planning ahead correctly. And 70 and over age, right? They know that they're reaching that age where they need to do something. But if I had a wish, anyone over 18 should have these two documents. They are no expensive, they are no complex, they are just you saying who can take over your shoes if you're unable to make decisions. You're just in a coma.
So once you do the power of attorney or the advanced health, that's not. I'm so sorry. Is it? Okay, someone's here. Never mind. Sorry. Does
No
it
worries.
have an expiration date?
Not necessarily. Very good question and no. The power of attorney and advanced health directive, they can be very, very specific. We can even do them for a specific time period, or we can do them only when it's needed and in specific scenarios. After death, will, trust, beneficiary name in accounts or different places and different tools that we could use. Okay. Thank you so much. Okay.
Curious on that one, For the
Yes.
POA and the other derivatives, do you have any clientels that have dual citizenship? And is it only US based at this point for accountability?
Yes, the answer is yes to both. So a power of attorney here in the States, it wouldn't work in another country. With Mexico, specifically with Mexico, there are laws that allow you to translate and make a power of attorney here valid there through a specific process, but simply by me going and taking my power of attorney, no, it doesn't work. Yeah, that's a very, very good question. And another thing that doesn't work either in any other jurisdiction is your trust, your will. They will not accept orders or something drafted by a different jurisdiction. Remember, it's different laws. So if you go to Spain, same issue, same things. You will have,
Like, for example, like me,
Mhm.
if I wanna do a good trust here, it won't work in Mexico. right?
No. No. And when you pass, your heirs are going to try to bring that, right? That's your estate plan. Mom did a estate plan, so let me go and show it to you, real estate agent, and their answer should be and will be, we cannot accept that because that's so.
But it sounds like the workaround to that is the actual translation in technology.
For trust and will, no. Realistically, the power of attorney, kind of. So remember that notaries in Mexico and in different jurisdictions, notaries have different powers. Here, the only power a notary has is to certify that the person in front of them is the person signing. In Mexico, they have different powers. And one of them is to be able to create, translate, or make active a power of attorney out there. So no, it's not simply a translation. No, but yeah, you have a point. You should talk to a notary. Yeah, in Mexico, yes. And for those that are thinking in or have property in other jurisdictions, you need to talk to an attorney out there to make sure that your state plan here matches the state plan there. Then one doesn't invalidate the other, right?
So we're talking, so I guess it's best to think about if you have any sort of material property in another jurisdiction,
Or if you move there,
or if you move there.
Mhm.
Okay.
yeah,
Those are the things that you think about.
you need to, yeah, and realistically, you should be talking to an attorney. Where your assets are, what your jurisdiction is. Everywhere you can just pay for a consultation, and that would save you a lot of guessing and a lot of issues.
Yeah, because even the state, the laws of California are different to another states, right?
And yeah, of course, in different countries, they're much complex, right? Much more complex. Okay, so let's see, what are the options that we all here have? Option one, we do nothing. We just understand, we learn about it and we do nothing. Your assets are going to pass by state law, which determine asset distribution. What does that mean? If I have a boyfriend, right, and we have lived together for 20 years and we purchase everything is our life, I want him to get everything, right? Everything I have because I have no one else, far away siblings or far away family members. If I don't do anything, will he get the things I wanted him to get? No, right? Why? Because he's a boyfriend.
Yeah, well,
He doesn't have like there is no relationship by law. There's nothing. It's just a partner or my roommate, whatever it is. What if I wanted to leave everything with my roommate? If you did nothing, what is the judge going to do?
common law would allow you to, assuming that you put together that law, haven't that law, common law doesn't even privilege.
There is a case now that says depending on the promise
Yeah.
of the other party.
And that's impossible.
But realistically, if you did nothing, your boyfriend is going to go and file, right? Like, or the roommate. Oh, we lived together for so long. We were the best of the friends. And yeah, what is going to do the judge? Notify every beneficiary that
Yeah,
could be there. And there would be an argument. I'm not saying there is no case, but yeah, it would be, it would be a very, very, very complex. But yeah, there's case law of that. And many other things based on promises. Beneficiaries and owners of assets entitled. One of the questions that I get very, very often, and one of the things that people do simply because it's easy, and mainly in my culture, in the Mexican culture, they add their children to the bank account, to the title of the deed of the house, everything. They do things like that. What happens with that is, if I have several kids, but only my youngest daughter is in the bank account, in co-owner of the house, in joint tenancy, I pass. And I did nothing. I don't have a will, I have nothing. Who's going to receive all the assets?
The young daughter.
Right? Because she's the joint owner
Yeah.
of the property, of everything I put her name in. So now it's going to be on her to decide whether or not to leave things to the other siblings, right? And that's when you are intentionally leaving issues for the next generation. Medical recovery. That's one of the main questions I get. Is the state going to take my house because I am in a nursing home and the government is paying for it, right? If you did nothing, yeah, the state has access to recovery of your assets. Next option, a will. A will is rather inexpensive. It's just a document that you could even do online. It's just explaining when I die, this is what I want to happen, A, B, C, and D. Divide my assets to these three people. That's it. And you list the executor. But yeah, the legal document specified asset distribution. After that, they allow your family to know what your wishes were. I want 100% of my things to go to my roommate or whatever it is. But this has to go through probate. What is probate? Very good question. Probate is the court. There has to be judge intervention. So do you think is that super fast and super efficient? It takes time, right? Filing documents, you hire an attorney, paying the attorney. It takes time. It takes time. Medical recovery, yeah. If it passes through probate, there is going to be, the state is going to have reached towards your assets. And again, attorney fees. If you hire an attorney, you hire a professional to work on your behalf, there are going to be fees.
So if you have a trust, then many houses have recovered or still does.
Correct, it does not. There is an exception to that. So the fun question, what is a trust? What is a living trust? One of the documents I do the most often. A living trust is a legal arrangement creating during your lifetime, right? You have to do it now, in which assets are transferred. So let's see. So my house, my everything gets transferred to the trust. I'm the trustee, I'm the creator, but I'm also the trustee. I manage everything for the benefit of the designated beneficiaries. While I am still alive, who is the beneficiary of my trust? Right? Yeah, exactly. Yeah, every person is their own beneficiary. When you are alive, you're the creator, you're the trustee, the one that manages, and you're the one that benefits from it. You can change, move, revoke. You can grab everything and just go travel the world. You can do anything and everything, but everything is not owned by the trust. Your home changes title, bank accounts, everything moves to the trust.
The trust.
Mhm.
That's your deed. Is that after the
No, it depends. Well, it depends, but I would say no if you do it right. Yeah, me and my husband, we are the owners of our home equally, and we are equal owners of the trust. So ownership is in the same exact portion percentages.
So how long were you under the ownership? does the county or does this,
The assessor's office.
yeah, do they see the period? They don't care how long you change it, as long as it's the same owner.
They have very complex ways to do it. But in general terms, while you are doing the trust, while it's being drafted, your attorney needs to pull the deed, check ownership, and based on that, assess if there would be any effects, any reassessment if you were to transfer the property. The deed has to be reviewed. That's part of the job.
Okay.
Yeah, so the answer is, if everything goes smooth, everything goes correct, you should know.
Okay,
But if there are issues, which I see maybe one issue with the deed, every 5 clients, every 5 trusts, someone did something wrong in the deed. They put community property when they weren't married. They put tenancy income, and they put in the name of a son just to get the mortgage, things like that. I see a lot of fun things.
And
So-
then, is your house needs to be paid off in order for your house contracts?
No. Okay, next. Allows your family to know your wishes. That's key, right? And family is not always blood related, is not always someone you married. A family could be just the family you created, the person you're with, the stepchildren, or the kids you semi-adopted. So that's very important. For me, it's one of the main things, your wishes. If you do a trust or even a will, you're able to decide who keeps what. It's based on your wishes. Another big item, benefit of the trust is that you avoid probate. So it's private. Your trust is not public to the world.
So
It's
how
right.
does it work? Like, let's say that I do, I live in trust and I passed away
Mm-hmm.
and, my kids, they don't need to go to court, they just,
They don't, because remember, everything is in your trust.
uh-huh.
Here, everything is not owned, everything is within, and you name a successor trustee. So-
And it's like, okay, so because then they, like, if I do the trust, then my house is gonna be on the deed is gonna be on the
Trust
trust.
Mhm.
So how that house passes onto them?
through trust administration. So what happens is then here in your trust, the trust now owns your house, owns every other asset. You leave clear instructions and distribution. Maybe you have 2 kids and you want them both to remain in the house. You're going to pass the house, but you want them to remain there. You want the house to be sold and split 50% equally to the children and the other 50% to a nonprofit.
See, so like me, I have a son that has a son, and I have over 2.2 guys, right? So let's say that I would want my house not to be sold and my son to live in there. And after he passes, maybe then they get the money or something else, but.
Something like that.
Something like that?
Yeah, you can put specific instructions. You can think about liquidity too. How are they going to keep paying for things? How if it's going to go 50-50, is one of the siblings going to pay the other off? So that's conversation to have, but yeah, structure wise, yeah, you can
So
be
basically,
any
I
specific.
can write whatever I want of my trust and that's how it's supposed to be like. For
You
example,
can be very specific. See, that way you can be very specific with your wishes, how things are going to be distributed and when, how and when, how to who and when.
and then like, let's say, like I said, like I do the living trust and then I pass. So then my boys, they need to find a lawyer to help them to understand or,
To do the trust administration, yeah, they could.
okay.
Yeah, and that's yeah, they could get an attorney to do the trust administration. Yeah. Okay, let's see if I answer protect minors. If you have minor children, you can of course name guardian and who's going to be the trustee that manages the money. Remember, that's very important, because something that I was very clear on since the beginning is you don't have to be old to do this.
Yeah.
If you have someone or something to protect, you should be interested in doing your estate plan.
That's only for the asset or for, life insurance? Too.
It's only for the assets or life insurance. Okay, life insurance is a little different. But life insurance, depending on the type of life insurance, like you can name a beneficiary there,
Yeah.
and it goes automatically to the beneficiary.
Oh, okay.
But for every asset that you can think of, there are different ways to go about it. It's just making sure that you have the right strategy for you, for your specific case scenario. Because what if you have a life insurance, some very large life insurance, and you're leaving the insurance to your wife? She's the primary beneficiary. And then the secondary beneficiary is a minor. What happens if husband and wife die in the same car accident? Is the child going to receive $1 million? Right? So that's why you have to be very, very careful with the strategies you do based on your current circumstances.
In case that, for example, I have today my second child is 19, and the third she's 16.
Mm-hmm.
If I'm doing trust, when she turns 18, I need to change it.
You don't have to. You don't have to unless one, there's someone to review, someone to update. Maybe now your children have grandkids, right? Have kids of their own, so you have grandchildren, and you prefer one over another one.
Oh, but no, because the minor turned
No.
18.
No, it is not like a trigger to change it. No.
Can I ask a question real quick?
Mhm.
So let's say I put my house in a trust, and I decide, okay, well, I'm gonna sell my house.
Mm-hmm.
Do I need to put that and deed on my name, or can
That's a
someone
very,
else-
very, very, very good question that you hit. Because what happens is selling the house, nothing stops you from doing it. But what I often see is people refinancing. So if your house is now here, you're going to refinance, you have to take it up, deal with everything you're doing, refinance, change, whatever it is. And the majority of people will forget to put the house back. If you take it out, you need to remember to put it back in. That was tied to that, but
But if I wanna sell it, I will.
yes, you can. Remember, you're the beneficiary, the one that manages everything,
And then
and yes, you can.
when I put my trust, does he have to have like a different name, my little trust?
It would be the living trust of the Garcia family.
Oh,
That's it. Mm-hmm. Or your specific name. Okay. So far, because I'm going to move to advanced healthcare directive. Any questions about wills, trusts,
yes, I
or
have
probate?
one more question, I'm sorry. So, cause I know there's like two different kinds
Hi.
of trust, the revocable and irrevocable living trust.
Oh, there are so many types of living trusts. There are so many types of trusts.
But the irrevocable one, you cannot change it before?
Exactly. The irrevocable is set in stone. And there are different types, but yeah, the one we're talking today about is revocable living trust. That can be modified the entire time the people that created it are still alive.
And if you decide to go with irrevocable, that's it, right?
If there was, but again, if you talk to an attorney, there has to be a specific reason why you're doing it that way. It could be tax
Especially
benefit.
like, let's say that someone is going to a nursing home and because they have dementia or whatever.
Mm.
And that's a good thing. Irrevocable, you can say.
Well, to be able to do all the paper we're talking about, you have to have capacity, right? So if you're already out there, you shouldn't be able to create or modify any of these
Then
legal
you have a power
documents.
of attorney or the whole thing.
So yeah, that's my question for that one. Like, if you have someone who is in a reduced mental state,
Mhm.
would the POA then take into effect in conjunction with your trust?
To modify the trust?
Yeah.
No. Generally, well, it could, but the majority of the powers of attorney that I create will not give powers to the agent, to the attorney, in fact, to be able to modify the trust, because there is a big, delicate risk that that person changes, the trust changes beneficiary, now it becomes the
Right.
sole beneficiary.
But in that case, it would only, if somebody's actually arguing or would actually take it to court, so to speak, the argument would be, there's really, in best case scenario,
Mhm.
family law agreement, POA is a to trust.
Remember that the power of attorney has restrictions as well, as it has powers.
Okay.
So generally, it is very well known in common practice, and you set certain restrictions to talk to people because yeah, if you lack capacity, you are giving your power away from what you decided before.
Okay.
So to go back to your question, is everything should be done before you are in that. Like,
Yeah, that's what I.
yeah, you never know. And another thing that happens with the majority of, with a lot of my clients is when you start aging, you become more vulnerable. That's true. So if you don't do anything, but you wait until the last minute, you run the risk of people trying to take advantage of you, right? Okay, Advanced Healthcare Directive. This is one of the most inexpensive documents that everyone should have because you can do it even at your doctor's office. Another attorney can do it, and we do it very specifically, but this can be as simple as having one who's your agent. If you are unable to make decisions because you're lacking capacity, you're unconscious, something, who can speak on your behalf? Who can choose a hospital, a doctor, accept or refuse treatment, or make arrangements upon your death? If you have 4 children, don't you think that every single one of them is going to want to make give an opinion, or whether or not you should accept or refuse a specific type of treatment, if they should keep you in life support, do CPR? Everyone is going to want to say something to the doctors. But if you have an Advanced Healthcare Directive, you leave your detailed wishes of what you want, treatment, hospital, doctors, everything, and you leave the specific person that is going to communicate that to the medical providers. It cannot be an operator or employee of a care facility. I had this question done many times because when someone is going through treatment of a long illness, they get really close with the doctor, they get really close with the nurse, and they want to give them this power. That's not allowed. You can't. Does it have to be family members? No, it can be anyone. Okay? Friends, anyone you trust and is going to be able to take your shoes. Yeah, as I said, it details specific life-sustaining treatment like CPR, feeding tubes, breathing machines, pain medicine, palliative care, things like that. Details organ donations, whether or not you wish to do that. And you can always restrict, we go back to restrict the agent's power. What that agent can and cannot say. Okay, a power of attorney already went ahead of the game on this one, but a power of attorney is a legal document that authorizes one person, the agent or attorney in fact, to act on behalf of another person, the principal, the creator of the power of attorney, in a specific matter, which can include financial, legal, healthcare decision. The scope of the authority granted can be broad or limited depending on the terms of the document. This power of attorney, I have seen it done very relaxed, people just giving them out as if they were coffee. This is a very delicate document, right? Because you are granting powers to another person. What if you grant powers to a family member, a brother, uncle out there, and you are in a coma for 7 years? If you don't trust this person enough and you're giving them enough powers to sell out your property, and there are fiduciary responsibilities and obligations to the attorney in fact, to the agent, but still, if you already gave power, you're putting yourself in a situation where you have to now fight back to get your
So
ass
the
back.
power only for example, one person, or you can?
You can do more than one. You can do more than one, yes. Or you can do
You just need to be careful who you.
and the powers that you give. Yeah.
And then, the power of attorney,
The lawyer doesn't, do you need to go to court to do anything or just?
No, but it has to be notarized.
Notarize?
And another question that I often get is, okay, I did a power of attorney for someone years ago, and we went and took it to the bank so that person could pay my mortgage. How do I set aside that power of attorney? And the advice is you do it in writing. Do it the same way that you created the first one, and do it to the same bank institution that you gave the first one.
And the power of attorney doesn't have, like, let's say that I give the power of attorney to someone that I no longer trust that person in every.
Revoke it, exactly. And my recommendation is that you do it in writing. And for the power of attorneys, there are also different types of power of attorneys.
And where do I, like, let's say that I revoke the power of attorney from that person. Do I go to court or?
No, let's say that you did a power of attorney for financial purposes, and you gave it to a specific bank to be able to grant powers to that person while you were incapacitated. You take your revocation in writing to that same institution. Okay, other things that I wish everybody did, aside from the estate planning. First, review your deed. If you have real estate, check how ownership is held right now. So ownership, joint tenancy, tenancy in common, know what your assets look like now. And that's free, you can do it if you have a deed. Make a list of every asset, every account, every life insurance that you have, homeowner insurance, and have your passwords safe, so not for the public, but available to your loved ones, and emergency contact. Imagine if something happens to you, the stress that your family is going through for what happened to you, and now they have to figure out, did mom have life insurance? Is there a homeowner insurance? Who are her contacts, emergency contacts I should invite to the funeral? What are the passwords so I can access her cell phone to see what account she had at the time of passing? So you see how this is someone no one talks about, but it's important, right? Okay, of course. And again, this is just something that I talk to my clients about very, very often. So that way they are able to, just as a reminder of important things that we all forget.
Could you include that in your will or your trust? You can exhibit.
You could, but many times, more often than I wish, a lot of people either do their trust and then they change businesses, they change bank accounts, things like that. So things change throughout time. So if you keep a list and you keep updating it because you remember, then it has to be done throughout your life. You don't have to change the trust, but you have to provide, you have that information available, because the trust, if it's properly done, is going to address that. I want my bank account to be distributed in this manner. You're not saying specifically the bank account in Wells Fargo with $100, and then you move the money to Chase. You're just being generous. So you could, but I would still want to see this as life changes. Emergency contacts, especially people that don't have family, they many times they choose friends to be the people or the agents or to be the emergency contact to if anybody needs them. As life goes, maybe that friend is not there any longer. So you need to keep that information available.
Yeah, I am. So like, let's say that I live in California and I have a trust here, but then I moved to a different state. Can they have a trust here in California if I have property in California and then open a new one in a different state or no?
You could, but remember what we said with their question of creating another another estate planning in another country. If you do that,
No, another thing.
no, that's what I'm saying.
Okay.
It's same risk. You run the risk of invalidating the existing one. So my recommendation, if you move and you already have a trust, talk to an attorney in that jurisdiction to review that everything that is there doesn't go against state laws.
Yeah, because like, let's say that I have a property here in California, but then I decide to buy a property.
That's very, very common.
Then I just go to a different, a lawyer in the state.
No,
and
you-
remove it.
No, that's different. Because there's a lot of people, a lot of us, we have property in different places where it's more affordable. So you live here, your state plan is here. You just have to make sure that that house is not forgotten, that is mentioned as part of or is funded to the trust. You don't have to create another trust. But your initial question was, what if I move to that state? And the answer is, grab your trust and go and get an attorney just to review it and make sure if that trust is still valid. Good for that, for the laws of the state. And I do that very often. And yeah, just because you move from state to state, it doesn't mean that your state plan has to be redone. Review beneficiaries on all your retirement accounts, all your investments, and bank accounts and life insurance. I forgot here. A lot of people, when they start working, maybe they put mom as a beneficiary. They start working in their 20s. When they're 40, they already have a wife, children. They already have a different reason, different family setting. But the beneficiary never changed. When they pass, if they pass, who's going to receive the money? The beneficiary, right? Automatically, the beneficiary. And what happens if that beneficiary is in government assistance? You are affecting her benefits because now she receives a huge sum of money. So inadvertently, you could be doing more harm than intended if you don't review your beneficiaries. That would be my same recommendation. Make sure you have a copy of everything in your trust. If you have a 401k, if you had a 401k before, print out the page of beneficiaries. It's so easy. You just have to log in, print it out, and confirm who your beneficiaries are. That's very, very important. Review or decide on funeral arrangements. The majority of people I talk to, they know what they want, but they haven't paid for it. If you don't do anything, who's going to pay for it? Your family.
Yeah, the family.
Where are they getting the money from? What, you don't know how expensive it is. Where are they getting the money from if your only asset was a house? Are they going to try to get the money from the house in a week? Right? So should be part of the conversation. If you're talking about estate planning, talk about funeral arrangements, what you wish, and start asking around how much money it costs, and consider doing life insurance. Or maybe start paying a payment plan. Let's decide, I want this is what funeral services I want, this is what I decided. It costs $10,000. I start paying. The insurances, yeah, no, they don't pay. No every time. Okay, so why I'm talking today about estate planning and business. So estate planning is, of course, is closely related to business ownership, because many times the business is super tied with the owner. Something happens and the business cannot continue running because there's issues with maybe co-owners, maybe there is a partnership, there's no clarity with the documents when you created the business, maybe there's no information as to who's the people that brings I don't know, people you purchase things with, the lease, things like that. You lose track of everything that is going on if only the owner is the only one with access to everything. Doing a business succession plan allows you to decide, taxes, costs, what is the best way to do it, liquidity, like have a safety plan, but it also helps you to think how the business is going to keep running and who you want the business to be kept running by. Maybe your children are not interested on doing that. So you have to decide, if I die, who's going to keep running the business, or the business runs the risk of being done when you're done. Okay, though if you have a business, documents that I would recommend that you keep handy for your family members, your attorneys to see, is the organizational and constituent documents. I'm talking about the articles of incorporation, the initial filings, financial and tax documents, business contracts and agreements, maybe someone that provides or delivers assets to you, you want to keep that handy. Ownership and assets records, licenses, permits, and regulatory documents, because many times the licenses and permits are tied to one specific person. That person dies, who's going to be able to renew those licenses and permits? Insurance policies, and minutes and resolutions. This is one of the main things I see people missing. They just don't have them. They are running the business and trying to figure out life without having that order. And that's it. Any questions?
How much is it how much it costs to do it?
Depending on the attorney then you hire.
Like, let's say now, I go with you. How much would
A trust would go between $2,000 to $4,000. That's the average. That's the average cost. Hourly rate, I am with we had a conversation. I had a conversation with a group of friends, and the average rate for an attorney in LA and Orange County is $575 an hour. Remember that. So yes, it is no inexpensive to do a trust.
Yeah.
But how much do you think your heirs are going to pay if you do nothing? Right? Simply by talking to me.
I know.
Yeah? 30 minutes is going to be.
What is the difference when a lawyer does it an extra day? Just like regular people, you know, people that do taxes.
Yeah, I see that very often. Reality is, the way I see it is, you going to a doctor versus you going to the lady in the corner that has herbs. I don't know how good they are, but you know that the attorney has the expertise to do it, and you have, like, there is a legal responsibility there. With the lady in the corner with the telling you the chochitos, I don't know, but yeah.
The lawyer does not.
So the price for only for the document shows it's equal 2,000.
Generally,
No,
usually-
but my question is,
Mhm.
that, we have to pay extra the hour,
No, generally something like a living trust should be like a package, like everything they are providing to you for that specific payment. Because imagine how much it would be if you call the attorney a week later. Hey, I have questions, and we get talking. It could add up very, very quickly. So no, generally no. In my practice, we don't do it that way, and I don't see other colleagues doing it either. We said that's a fee, and that's a fee for the interview, strategy, investigation, and drafting.
oh,
And
And
then,
then, like, let's say that I go to the lawyer or to
Mhm.
the interest, then you will help me to do the transfer of my deal.
everything should be supported by the
And
attorney.
it doesn't have to be notarized or no?
Yes, and generally it should be notarized. In my case, we have a notary, And another thing is that all the documents that I mentioned, they should be part of your estate plan, right? So you go to the attorney and you do everything, not only one document, not only a single document, it's everything.
It's more difficult if you come in with already.
With what?
Somebody else already.
That's very, very good question. Generally, the cost doesn't change but it's highly, highly unlikely that I am going to be okay simply adding one provision or a little change to a document created by someone else. Because if there are mistakes done there in the core of the document, now I am entangled with it. So I would say 100% of the times when someone comes to me with a trust done by someone else, we review it and everything, but I'm going to do an entire new document because now I am responsible for it. I know every single word that is in that document, and it's in to me.
But if you were to do that, then you would have, so then, in your case, would you be negating the superseding the old document or negating
Correct.
it altogether?
Correct, and it has to be a specific provision that says that everything before this is revoked. And this is what we do is an amendment and restate of the document. Saying like this takes over, this takes precedence.
So you're technically doing two documents, then you're doing the amendment and you're doing.
The amendment is also the new document, right? Yeah, and yes, it takes place.
Do you have to pick both of them or?
Yeah.
You do.
Let's see,
Do you need to have a living trust and a will?
generally,
Because I know the living trust is not better, but you can have a will.
generally we do both, because what we do is something called the pour over will. This catches everything and says there's all the identification of the document, but I need everything to my trust. You see how they're connected? Yeah.
So it won't matter, like you're not, you don't need to take the will for that.
No, it is, and it's a lot of information.
If the asset or the, is outside of California, that, is giving him a good it's, you can do a trust, like,
I'm sorry, I didn't repeat that.